And welcome to today's Board of Commissioners zoning hearing. I'm pleased today that we have Pastor Lysandra Bell with us. She will be bringing our invocation, and she is with Enlightened Christian Center. Following her invocation, I will lead us in the pledge. For those of you willing and able, please rise for our invocation and pledge.
Good morning. Good morning, Chairwoman Cupid and commissioners and board members. Thank you for this opportunity. It is a blessing to be able to pray with you all, and I'm honored to be invited today. Thank you. Father, we do thank you, Lord, for your goodness. We thank you for this day. This is the day that you have made, and we choose to rejoice and be glad in it. Father, we just pray and invite your presence into this meeting today. We thank you, Lord, that every item that is on the agenda today, Father, that you will orchestrate the decisions that need to be made, that you will provide the clarity and direction and decisions that need to be made. We thank you, Father, that we are blessed to live and be a part and have businesses in this wonderful community, this county. And Lord, we just pray that it would just grow and be even better and better and better, Father. I thank you, Lord, that it will just become a community that's just highly desirable across the entire state and even across the nation. And so, Father, we just invite your peace. We pray for your peace on all the board members and their families, and even for those that are in attendance. And Father, we give you all the praise, the glory, and we thank you for being Lord and Lord of this community and of this county. In Jesus' name, amen.
Amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Our meeting is now called to order. We have today our zoning manager, John Peterson, and he will walk us through today's consent agenda.
And thank you, Madam Chair and Board. Today's hearing will be conducted with the following process and procedure. Each case will be called in numerical order. When the case is called, we would ask that the applicant please stand and raise a hand to show that they are in attendance. Then after that, we're going to recognize anyone here who is opposed to that case. We would also ask that the opposition please stand up and raise a hand so they can be counted for the record. Then, after recognizing both parties will be asked to come forward to be sworn in so they can present testimony to the Board of Commissioners. The applicant will testify first, and then the opposition, if any, will testify second. It's important to note that each side only gets 10 minutes to state their case of concerns. There's not a process to reserve your time, and there's not a rebuttal process. So convey all your information to the board within your 10-minute time frame. Additionally, if there's more than one person wishes to speak on a case, you may want to coordinate with each other about what you're going to talk about, because each side only gets 10 minutes, and you don't want to cover the same information twice. Then after that, the board will discuss the case at hand. They may ask one or more speakers to come back to the front for additional comments or questions. And then after that, the board will make a decision to either approve, deny, hold, or continue the case at hand. There is one case, there are 5 cases on today's printed agenda which have been withdrawn without prejudice, and these cases will not be heard today. First case is rezoning case Z28 of 2022, Parent Homes, care of Whit Porter. This case has been withdrawn without prejudice and will not be heard today. Rezoning case Z31 of 2022, Lot 1 Homes. This case has been withdrawn without prejudice and will not be heard today. Rezoning case Z33 of 2022, Pulte Home Company. This case has been withdrawn without prejudice and will not be heard today. Rezoning case Z37 of 2022, Synergy Investing, LLC. This case has been withdrawn without prejudice and will not be heard today. Other business item number 31 of 2022, First Center Incorporated. This case has been withdrawn without prejudice and will not be heard today. Additionally, Madam Chair and Board, there is one case on today's agenda in which the applicant is asking for this case to be withdrawn without prejudice. That would be other business item number 15 of 2022, Mountain Prize Incorporated. The applicant is asking this case to be withdrawn without prejudice, Madam Chair and Board.
Thank you, John. Commissioner Gambrill?
So moved.
Second. Is there any discussion? It's going to be withdrawn without prejudice, John?
Yes.
Correct.
Okay, just want to clarify. Okay. Call the question. The motion passes 5-0. Thank you.
Thank you. There are a number of cases on today's printed agenda which have been either held or continued by the staff of the Planning Commission, and these cases will not be heard today. First case is rezoning case Z7 of 2022, KM Homes. This case was continued by the staff until the July 5th, 2022 Planning Commission zoning hearing. So Z7 of 2022 will not be heard today. Rezoning case Z21 of 2022, Francisco Padilla. This case was continued by the Planning Commission until the July 5th, 2022 Planning Commission zoning hearing. So Z21 will not be heard today. Rezoning case Z24 of 2022, Davis Enterprises LLC. This case was held by the Planning Commission until the July 5th, 2022 Planning Commission zoning hearing. So Z24 of 2022 will not be heard today. Rezoning case Z26 of 2022, Duke Realty Limited Partnership. This case was held by the Planning Commission until the July 5th, 2022 Planning Commission zoning hearing. So Z26 of 2022 will not be heard today. Rezoning case Z29 of 2022, Maria del Carmen Rodriguez. This case was continued by the staff until the July 5th, 2022 Planning Commission zoning hearing. So Z29 of 2022 will not be heard today. Rezoning case Z34 of 2022, Rise Properties LLC. This case was continued by the staff until the July 5th, 2022 Planning Commission zoning hearing. So Z34 of 2022 will not be heard today. Rezoning case Z35 of 2022, Morrison Building and Investment LLC. This case was held by the Planning Commission until the July 5th, 2022 Planning Commission zoning hearing. So Z35 of 2022 will not be heard today. Rezoning case Z36 of 2022, David Gannett. This case was held by the Planning Commission until the July 5th, 2022 Planning Commission zoning hearing. So Z36 will not be heard today. Rezoning case Z38 of 2022, David Pearson Communities Incorporated. This case was continued by the staff until the July 5th, 2022 Planning Commission zoning hearing. So Z38 of 2022 will not be heard today. LUP 8 of 2022, Donna Jordan. This case was continued by the staff until the July 5th, 2022 Planning Commission zoning hearing. So LUP 8 of 2022 will not be heard today. LUP 10 of 2022, Jose A. Orlano. This case was held by the staff until the July 5th, 2022 Planning Commission zoning hearing. So LUP 10 of 2022 will not be heard today. SLUP 5 of 2022, Parallel Towers 3, LLC, also known as Parallel Infrastructure LLC. This case was continued by the staff until the July 5th, 2022 Planning Commission zoning hearing. So SLEP 5 of 2022 will not be heard today. OSC 1 of 2022, Green Community Development LLC. This case was continued by the staff until the July 5th, 2022 Planning Commission zoning hearing. So OSC 1 of 2022 will not be heard today. Other business, item number 24 of 2022, Hal Simpson. This case was continued by the staff until the July 19th, 2022 Board of Commissioners zoning hearing. So other business, item number 24 will not be heard today. Other business, item number 26 of 2022, Reich Properties LLC. This case was continued by the staff until the July 19th, 2022 Board of Commissioners zoning hearing. So other business, item number 26 of 2022 will not be heard today. I would like to ask the people in today's audience, if you have a cell phone, please turn your cell phone on mute. When the phones ring, they do interfere with broadcast presentations, so please put your cell phones on mute. Any person wishing to speak before the Board of Commissioners must file a campaign contribution disclosure statement. If within 2 years immediately preceding the filing of a rezoning application, a campaign contribution totaling $250 more is made to a current member of the Board of Commissioners. Additional information about this requirement is located on the table in the back of this room. And I want to remind applicants, opposition, and any interested party that information is due to this board the Wednesday prior to this hearing. Any information submitted after the Wednesday due date may or may not be considered by the board at their discretion. With that, Madam Chair, Board, I'm ready to start the consent agenda. Thank you. Cobb County Board of Commissioners, zoning hearing consent agenda for June 21st, 2022. First case on consent is rezoning case Z20, Francisco Padilla. The applicant requests a rezoning from R20 to NRC for retail and office in land lots 488, 489, and 549 of the 19th District. The property is located on the northwest side of Powder Springs Road, north of Miller Lane. The Planning Commission recommends deletion of Z20 to the El Oro zoning district, subject to the following conditions. Number one, site plan received by the zoning division on February 3rd, 2022, with the district commissioner approving minor modifications. Number two, letter of agreeable conditions from Mr. Garvis L. Sams Jr. dated May 31st, 2022. Number three, fire department comments and recommendations. Number four, water and sewer division comments and recommendations. Number five, stormwater management division comments and recommendations. Number six, Department of Transportation comments and recommendations. And number seven, variances identified in the zoning comments. The applicant's representative is present. Is there anyone here opposed? Rezoning case Z20?
No.
Let the record show there's no one opposed.
If I can add to that, please.
Yes, go ahead.
Okay. I'd like to include the supplemental stipulations and conditions pursuant to the District Commissioner's direction letter dated June 20th, 2022 from Garvis Sams.
Okay. Does
Okay.
clerk have the letter?
Yeah, I got it.
I have it. I can give it to her.
And is the applicant okay with that? Yes, ma'am. Okay, thank you.
Okay, next case is rezoning case Z30. Joseph Fiamingo requests a rezoning from R20 to LRO for a contractor office in land lot 421 of the 16th district. The property is located on the north side of Blackwell Road, across from Fowler Drive. The planning commission recommends deletion of Z30 to a limited professional services permit, subject to the following conditions. Number one, pursuant and specific to this particular owner. Number two, all other staff comments and recommendations. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to rezone case Z30?
No.
Let the record show there's no one opposed. Next case is SLEP 8, Auto Nation Incorporated, request a special land use permit for an automobile and truck sales used car lot or pre-owned in land lot 172 of the 20th district. The property is located on the west side of Barrett Lakes Boulevard, south of Cobb Place Boulevard. The planning commission recommends approval of SLUP 8 subject to the following conditions. Number one, all cars to be parked in marked parking spaces. Number two, fire department comments and recommendations. Number three, water and sewer division comments and recommendations. Number four, stormwater management division comments and recommendations. And number five, Department of Transportation comments and recommendations. Is the applicant present?
Yes.
Let the record show the applicant is here. Is there anyone here opposed to SLUP 8?
No.
Let the record show there's no one opposed. And moving into other business items on the consent agenda. First case is other business item number 27 of 2022, which is to consider a stipulation amendment for Elvia Benitez regarding rezoning application Z19 of 2017 for property located on the east side of Mapleton Parkway, north of Community Drive, in land lots 189 and 190 of the 18th district. Staff recommends approval, subject to the following conditions. Number one, installation of a 20-foot landscape buffer adjacent to the eastern property line, and installation of heavy landscaping for the beautification of screening in the grassy area to the northwest of the building. The size is approximately 300 square feet. To be installed no later than October 21st, 2022. Landscape and buffer plan to be approved by the county arborist and the district commissioner. All landscaping to be maintained with any dead or damaged landscaping to be replaced within 60 days. Number two, hours of operation to be 7 days per week from 9 a.m. to 8:30 p.m. Number three, the use shall be limited to a clothing retail store, which includes but is not limited to clothing apparel, footwear, and apparel accessories. Any other use shall be required to come back to the board for approval. Number four, sidewalk sales are prohibited. Number five, no outside storage of merchandise or other items. Number six, Cobb DOT comments contained in the other business packet. And number seven, fire department comments contained in the other business packet. And number eight, all previous stipulations not in conflict with this amendment to remain in effect. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 27?
No.
Let the record show there's no one opposed.
Madam Chair, I'd like to add
Go ahead.
to the stipulations. Stipulation number 3, revise it to reflect the use shall be limited to a clothing retail which includes new clothing apparel, footwear, and apparel accessories. Any other use shall require the approval of the Board of Commissioners. No expansion of the current building footprint without the approval of the Board of Commissioners through a rezoning application or other business agenda item. And any dumpsters on the property shall be placed in a dumpster enclosure behind the building. The dumpsters must have doors and are to remain closed when not in use. The enclosures must meet county standards. That's the end of my revision.
Thank you, Commissioner. Is the applicant here? Is the applicant okay with the stipulations that were read? Okay, thank you. For those who are listening from home, the applicant is okay with the stipulations. Thank you.
Okay, next item is other business, item number 28 of 2022, which is to consider a stipulation and site plan amendment for East Cobb Senior Living LLC regarding rezoning application Z41 of 2010 for property located on the south side of Lower Rawls Road, east of Cove Drive, in land lots 1114 and 1115 of the 16th District. Staff recommends approval, subject to the following conditions. Number one, the letters of stipulations for Mr. Parks Huff dated June 15th, 2022 and June 16th, 2022. Number two, Cobb DOT comments. Number three, water and sewer comments. Number four, stormwater management comments. And number five, fire department comments. The applicant is present. Is there anyone here opposed to other business item number 28?
No.
Let the record show there's no one opposed.
Madam Chair, I'd like to ask a couple of questions on this one. Well, Carl, I would like Carl. Hi. So I'm fine with this on consent. I just wanted to make sure from a stormwater aspect, we're adding 6 additional units, that was looked into, because I know that there were some previously noted issues with regards to stormwater with the nearby neighborhood, and just wanted to make sure that that was something that was being taken under consideration or with regards to this particular application, and then wanted to call Parks up to just confirm he's good with making sure we're updating making any changes that need to be made.
I would have to look back at the file again to see if they're increasing the impervious area over 5,000 square feet. Typically, if it's under the 5,000 square feet, we don't require it. But if there's downstream issues, that we could look into that.
Okay.
I'm sure they'll have to get a land disturbance permit, and then we'll review it for that at that time.
Thank you. Thank you. And Parks, you can approach. If I incorporate just an additional language saying that there will be some, consideration of those downstream impacts as a part of this change.
Certainly. Be glad to.
Thank you.
And if I can, ECCA supports this. They asked me to make one modification, if I can read that, their request.
Okay.
And on my letter of stipulation number 4, I say Sterling will have a alternative parking plan, because when it's under development, there are going to be some parking spaces that will be taken up by other things. So, and I said Sterling will ensure that there isn't any parking on adjacent rights of way. What she wanted me to change is say that there won't be any parking on adjacent public roadways, including adjacent neighborhoods, just being real clear that there won't be any parking in the adjacent subdivision, streets, or any other public roadway. So that was a request ECCA that I told them I would ask to be changed.
Okay, I am agreeable to that change. Okay.
And then I think you have a DOT question. I do have, if you talk to DOT.
No DOT question.
Okay,
That was
so
it.
we're
It was
getting
just
ready
the
to have a
stormwater.
hearing if there's one more person that comes up.
There's a setback issue that I'll have to ask it to come off consent to address the DOT issue.
Yeah, so this is.
Okay. Okay.
Okay, so pull that one off consent. Okay, so other business, number 28 is off consent. Next case is other business item number 29 of 2022, which is to consider a site plan amendment for North American Properties regarding rezoning application Z118 of 1997 for property located on the north side of Rouse Road and on the north and east sides of Marwell Drive in land lot 16 of the 1st District. Staff recommends approval, subject to the following conditions. Number one, email from Mr. Rick Room dated May 28th, 2022, which includes the attachments. Number two, stormwater management comments. Number three, fire comments. Number four, site plan received May 25th, 2022, with the district commissioner approving minor changes. Number five, all previous stipulations to remain in effect. And number six, email from East Cobb Civic Association dated June 15th, 2022, which includes the attachments. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 29?
No.
Let the record show no one opposed.
This is the one where I have one question for you. You can come up or come to the podium, please. Applicant. Thank you. I know there have been some consideration around the queuing efforts with having the valet in the back. And what I wanted to do is just make sure that there, as a part of this particular zoning, kind of read into the record, that there really is a coordinated effort with DOT to make sure that we don't cause any backlog of traffic, because we have some multimodal uses with people biking, we have the car rides, et cetera. So would you be amenable to me adding some language with regards to some type of multimodal plan to address the backup?
Yes, ma'am, we would.
Thank you.
Thank you. Just need for you to articulate.
Yes, I'm
what
working on that
stipulation
language.
is.
Thank
Okay,
you.
got it.
So it'll be that the district commissioner, upon district commissioner approval, that there is coordination for a queuing plan in order to address the multimodal uses and ensure that just a district commissioner approval.
Yes. and
Thank you.
That sounds more clear. Just,
Okay,
okay.
thank you.
Thank you.
Okay, next item is other business, item number 30 of 2022, which is to consider a stipulation and site plan amendment for Triton LLC regarding rezoning application Z18 of 2006 for property located on the northeasterly side of Floyd Road and on the westerly side of Hicks Road, south of Concord Road, in land lots 29 and 30 of the 17th district, and also land lots 1,000 and 1,073 of the 19th district. Staff recommends approval, subject to the following conditions. Number one, site plan received by the zoning division on May 17th, 2022, with the district commissioner approving the final site plan. Number two, letter from Mr. Kevin Moore dated June 16th, 2022. Number three, Cobb DOT comments. Number four, fire department comments. And number five, all previous stipulations to remain in effect. The applicant is present. Is there anyone here opposed to other business item number 30? Let the record show no one opposed. And that completes the consent agenda, Madam Chair and Board.
Thank you. Commissioners, are there any additional changes that need to be made to the consent agenda? Okay, with that, I make a motion that we approve the consent agenda as revised.
Second.
Is there any discussion? Call the question. The motion passes 5-0. Thank you. For those of you who had items on consent that have been approved, you are free to leave or you are free to stay, but your matter has already been addressed except for one item which is remaining, which is other business item number 28. John, we'll just take a minute so they can go. Okay.
Okay, thank you. And Madam Chair and Board, the next zoning case has a companion special land use permit with it. Would it be the board's wish to hear these together and then just make separate motions in both cases?
Yes, John.
Okay. Okay, next case is rezoning case Z78 of 2021, St. Benedict's Episcopal School. Request rezoning from O&I in R20 to O&I for a school in land lot 695 of the 17th district. Property is located on the east and north side of Daniel Street and on the west side of Cooper Lake Road. together with its special land use permit number 11 of 2021, St. Benedict's Episcopal School requests a special land use permit for a school in land lot 695 of the 17th District. The property is located on the east and north side of Daniel Street and on the west side of Cooper Lake Road. The applicant is present. Can I get a show of people here who are opposed to rezoning case Z78 and SLUP 11?
And plus additional affidavits for 2018.
Okay, let the record show there are 3 people here in person opposed, and they're going to present an affidavit when they make their presentation. Can I get a show of people here who are in support of rezoning case Z78 and SLUP 11? Let the record show there are 13 people here in support of these 2 applications. All those who wish to address the board, please come forward to be sworn in.
You can go ahead when you're ready, Kevin.
Thank you, Madam Chair. Commissioners, my name is Kevin Moore. I'm here on behalf of St. Benedict's in this application for rezoning and special land use permit that we've now heard before you now a couple of times, and certainly we had a very exhaustive presentation and hearing 2 months ago. So I'm not going to repeat that. Just going to approach you today, discuss what has happened since that time, and the directive that we were given, and try to certainly highlight some of the important considerations for you today. If you recall, at the hearing 2 months ago, Cobb County Department of Transportation, Cobb DOT, had a alternative design for the roadway network and intersection of what is Daniel Street, Atlanta Road, and Cooper Lake Road. So I'm going to step over just so I can go through that with you. But at that point in time, that design alternative, which is on the screen before you now, it was our directive to take this new design and update, not really update, but do a traffic study for this particular design alternative that had been proposed by Cobb DOT. This would be a new traffic study. This would be the 6th traffic study as it relates to this particular application, as it's been updated and different proposals and alternatives have been reviewed and considered with updated traffic studies. And so we have completed that study. It did take a good deal of time. Traffic studies take a good deal of time because of the complex nature of what has to be undertaken, studied, and modeled. And I'll go through that with you and certainly highlight those pieces to you. All right, just to remind you and orient you again, this is Atlanta Road heading south to its intersection with Cumberland Boulevard. This is Cooper Lake Road and Daniel Street. Cooper Lake Road continues on south as well, and then ultimately winds itself back around to South Cobb Drive to the west of this location. Again, this is Daniel Street, Cooper Lake Road, and today, where you see this green area, is the intersection. There's a 4-way stop here, and then the intersection with Atlanta Road here. This is the subject property for St. Benedict's for its proposed relocation of its middle school. The existing St. Benedict's campus, again, is located here as the main campus, and also, if you go further south on Cooper Lake Road, they have an additional 2 buildings as part of their overall private school. To fill you in also, you have a portion of this property here is the existing Cobb County Park. It's a small park that functions very well and is of great benefit to the community. The proposed design was by Cobb DOT was to eliminate this problematic intersection. To remind you, Daniel Street, 4-way stop with Cooper Lake Road, and then a very short leg to Atlanta Road here where there is no traffic light. This has long been recognized for more than a decade as a problematic intersection that does not work for a variety of reasons. And in fact, in its current condition, it does not work. In its current condition, it has a level of service of F. which is the lowest it can be in terms of its level of service in the AM and PM peak hours. That's its current level of service, regardless of whether St. Benedict's is permitted to construct its middle school. That level of service is F as of today. To remind you, that's also why when this property was rezoned directly across Atlanta Road, that was rezoned in 2004. It carried with it a stipulation that this owner and applicant that developed this property here would, if a traffic light was ever warranted by DOT, participate on a pro rata basis. As one of its stipulations, it was recognized as far back as 2004 that this particular area along Atlanta Road had problematic traffic congestion. The proposal from Cobb DOT was to close this particular leg of Daniel Street at this intersection and reroute it and create a new intersection that would acquire a portion of existing St. Benedict's property here, have a traffic light here, and also provide for a little reworking of Cooper Lake Road here. In general terms, it places the traffic light in this intersection a little further south in a little bit better positioning as it relates to the signalized intersection with Cooper Lake Road to the north and the signalized major intersection with Cumberland Boulevard to the south on Atlanta Road. In addition, by arranging it in this manner, it provides better stacking and movement through this intersection. As a result, that's the design that was proposed by Cobb DOT. We did undertake to do an extensive traffic study and work with Cobb DOT on those parameters and modeling. That included making sure that we took into account all aspects of student enrollment that would be proposed, both current and, importantly, though, ran the modeling based on the maximum number of students for the entire St. Benedict's campuses. In addition, that study took into account both the functionality of this new proposed intersection as well as the surrounding intersections as part of that study. The end result of this traffic study, which was submitted to Cobb DOT last Tuesday, is that this intersection would function at a level of service of B, so far, far better than the current level of service of F. And again, this is a system improvement, and again, it comes with the commitment from St. Benedict's, as we announced 2 months ago, that St. Benedict's would likewise be willing to make a financial contribution of $200,000 to this condition as part of fixing what is a county system problem at this particular intersection, and that commitment remains true today. Unfortunately, since that time, here you go. Unfortunately, since it was submitted last Tuesday, DOT has not been able to complete its analysis of that traffic study, which they undertake, and again, it takes them time to do that as well. This is a situation where the parties and the people involved had done and worked very hard to get to this point, but at this point, DOT has not completed their analysis, and they sent that out by email on this past Sunday evening. Be that as it may, I am providing you what the analysis that we did by the independent traffic engineer stated in terms of the level of service and how that worked for this proposed intersection. Also given that this would be a joint project from both a private entity such as St. Benedict's, the owner across the street who's bound by those stipulations that require their contribution, as well as the county, as it well should be, as a complete system improvement. All the parties that are involved have been and are willing to make those commitments, at least from the private owner across the street and the private school of St. Benedict's. And I also want to remind you again the importance in this case in terms of some of the legal considerations. I mentioned last time and reviewed with you the Religious Land Use and Institutionalized Persons Act, which is applicable here because this is a private religious school. And because of that, there are certain legal considerations that we believe are important for your consideration as well. And I want to remind you that, again, in this situation, that St. Benedict's not has to be treated equally, but must be treated as well as non-religious assemblies and institutions. So St. Benedict's must be treated as well as the private development that went in across Atlanta Road, wherein the Board of Commissioners approved that rezoning with the allowance for a pro rata portion of a traffic light. to go in there to address this very same traffic problem. Moreover, they have to be treated and such that any compelling governmental interest must be pursued in the least restrictive way possible as it relates to their application. And we believe those are important considerations here so that St. Benedict's can be treated not just equally, but as well as private developments have been treated in this particular area that have all dealt with this exact same traffic problem that has been highlighted for us today and throughout this process. Again, we have done what was asked of us, and St. Benedict's has done that by providing a full new traffic study of a new design that was proposed as a design from Cobb DOT, and continue to make that commitment for this proposal. With that, again, St. Benedict's is more than happy and willing and commits to coordination with Cobb County as it relates to this design as part of any approval of the rezoning and special land use permit applications, as well as again commits to a $200,000 contribution as part of this proposal to add its share into this situation. With that, I'm here, can answer any questions that you may have, as well as representatives of St. Benedict's, which have been available at all times. Again, we respectfully request your approval or further action on this matter. Thank you.
Thank you. We now have 10 minutes for opposition, and there were multiple persons that stood up. Just be mindful of time, so each person that desires to speak has an opportunity to do so.
I'm Mary Rose Barnes. I speak on behalf of Oakdale Community Association Board. OCA Board stands in opposition to this plan. What plan? What site plan? What information? What hours? What queuing line? We have nothing this morning. There was no stipulation letter nor new revised site plan presented. This is what we have come to expect through the years since 2008. Anyway, from this applicant, this is unconscionable. The hold of this item was contingent upon a community meeting, which has not occurred. We have not heard from the applicant, nor anyone that I know of in the neighborhood has heard from the applicant since April. There's this is be blindsided this last moment. We didn't know what the applicant was even going to do. Were they going to ask for a withdrawal or a continuance or another hold? We did not know. We did not expect them to present an application without any information. There has been no progress in the 7 months on this project. Generally, holds are not allowed more than 2 times. And the 2004 zoning decision that Mr. Moore talked about was contingent upon a light at Daniel Street. That applicant, that person across the street, that owner was not responsible for a light anywhere else. Enough is enough. A denial is the only reasonable outcome of this application. Thank you for your cooperation and your consideration.
Thank you. Have our next speaker.
Hello again, Christina Kreitzer from Kensington Green. As Mary Rose Barnes stated, the actions coming out of the last committee meeting that I shared with you guys in a letter this past week, the revised traffic study, yes, it was submitted, and we can get into semantics. As Kevin Moore mentioned, the DOT has not had time to review it, but they've also provided verbal confirmation mid last week that they reject the traffic study because it did not include the information that was requested for the full population, amongst other items, as spelled out in the last meeting, in the meeting before that, in the meeting before that. And while the intersection has indeed gotten worse over the past 10 years, so have the continued attendance expectations and exceptions granted for continuing to grow St. Benedict's on non-major infrastructure roads, and that is why there's a problem. It is not because it's a religious institution. That has nothing to do with it. It has to do with the fact that we are trying to fit an O&I situation into an R20 zone according to the Master Comprehensive Plan. That is causing the traffic problems because it was never intended to carry this volume. So as Mary Rose said, for the OCA and Kensington Green and the 28 other families that you already have previously been given the affidavits for, we do continue to ask for denial of St. Benedict's in this location.
Thank you.
And Hal, did you want to come up?
My name is Hal Colbert. I reside at 2005 Kensington Green Drive Southeast here in Smyrna. And I'd like to address the comprehensive land use plan for a minute. I'm a 30-year member of the commercial brokerage and development community. I work all over the Southeast, and I deal in a lot of communities that have comprehensive land use plans. And I can tell you almost to the letter, every community follows those guidelines. When I bought my home here a couple of years ago, I saw the vacant site. I did a little research to see what was going on there. And I saw it was medium density residential, 2.5 to 5 units per acre. I further saw that there was an attempt in 2016, I believe it was, to upzone from the 5 units to the acre to 5.06 units to the acre. One additional unit for residential development, and it was denied by the, I don't think you turned them down specifically, but you said that it had to be toward the lower end of that scale, toward the 2.5 units per acre, and so the applicant apparently dropped that. So I was convinced that this would remain a residential site and not become a commercial institutional site, and I will submit to you that changing zoning on a major thoroughfare is totally different than changing zoning on a site like this, where you're restricted with these very small little streets. I put a tape measure on Daniel, and Daniel is 16 feet wide. Weaver is 18 feet wide. I did not tape Cooper Lake, but I think this is the wrong use for this site. I've sent you several letters saying that. And quite frankly, I'm very surprised it's made it out of the planning department with a recommendation to approve. The site is too small. It's almost an acre too small for this use. And the infrastructure is totally inadequate for this use. So I would like to ask that you deny this. And yeah, I think you would be doing the school a big favor as well, because they could find a better site on a better thoroughfare and not have the congestion that's going to be happen here. And we heard loud and clear at one of the last meetings, our own traffic engineer talked about the congestion at Cooper Lake and Daniel. This new study by their engineer shows some improvements or a modification onto Atlanta Road. It says nothing about the congestion up on Cooper Lake and Daniel, with all of those people dropping off and picking up at the same times every day. So I'd request that you deny this application. Thank you.
Thank you. Are there any additional speakers? All right, that concludes the opposition. I'll turn things over to you, Commissioner.
Thank you. All right, we've got a lot to unpack here. I would like to have Amy come up first.
Amy Diaz, DOT.
Thank you. So the first question is around the rejection of the traffic study. What was the rationale for just the rationale for the rejection?
I was actually out of the office last week, so I was not part of that conversation. But I know that one of the director's concerns is that the traffic study states that that improvement to realign Cooper Lake is a planned Cobb DOT project. And where it has been considered, it does not have funding, it's not planned, it's not on any list anywhere. So I know that that was one of the major concerns that was raised while I was out.
Okay, thank you. And then another follow-up question to that is, with regards to the communication between the applicant and DOT, I know that there had been some direction even before this particular idea, and I'll ask the applicant as well, but before this alternative approach was designed, that there was a desire to look at the design on the table and making sure the numbers were correct, and then in general, making sure the numbers were correct. Can you speak to the correspondence that existed between staff and the applicant?
So I can speak to some of the correspondence before the traffic study was completed. I will also state that Abby with DOT, Abby Reddick, is digging into all of the numbers too. That's one of the reasons why this thorough, in-depth review is taking a while, is because we are making sure all those numbers are there, all the I's are dotted, P's, and all that stuff. The thing that we coordinated beforehand was one of the big issues was, were they accounting for all the students? And because they're shifting from campus to campus, it was confusing. We had several weeks of emails, including graphics of, well, these students move from here to here, and these move, and so to try to make sure that we were understanding exactly what was happening, and no students were either getting double counted or not counted at all. As it turns out, the traffic study, as my understanding, I haven't had a chance to dig into the numbers, but what they are doing is they have the maximum of the existing campuses that are currently allowed, plus all the additional students at the new campus. So it should basically be just like it's taking the new campus into effect without shifting students at all, because those other campuses, they want to keep the possibility of increasing to the current max students.
Okay. So you're saying the assumption before the final, obviously we haven't analyzed the traffic study, but the assumption for their parameters were kind of the worst case scenario?
Yeah, previously they had basically said, because of the 120 or 160, how many students were shifting from the Weaver Street campus up to the new campus, they had deleted that number of students and shifted them around on the network, but not included them as new students. The new traffic study is supposed to include all of the students at the new campus as new students and have the existing campuses at their current maximums.
Thank you. Those are my questions for you. I probably will bring you back up again, but
Sure.
before I let you go, I'm sure there may be some other questions that the commissioners have as well.
Amy, do you know what the estimated cost is for the proposed project that he was showing?
So I'm still getting finalized numbers for that. I received a cost estimate of basically $775,000, but it did not seem to include the traffic signal. So my estimate is going to be close to $1 million.
And that includes obtaining right-of-way? Because I know that's usually the most.
It does include right-of-way impacts, I believe. But again, I'm getting all that confirmed.
Okay, because I thought the last time we had talked about it, this was a $2 million project, so that's why I'm a little surprised.
That was the number I'd heard too.
Yeah.
Yeah, I followed up on that estimate yesterday, which was my first day back, even though it was a holiday. So that I haven't gotten the final confirmation, but it is well over the $200,000 that they're willing to donate, if that is the point.
Thank you.
Are there any other questions for Amy? I have a question, Amy. This is not the first time this has been delayed to assess traffic impacts and to have a study. Can you give us a timeline with respect to what was submitted, how long it would take for it to be evaluated?
So my general rule of thumb for a normal location is a week, that we have to have at least a solid week. It was turned in Tuesday, and of course that is technically a week. It was turned in the end of the day Tuesday, and Monday was a holiday, and plus complicated also by the fact that I was out sick last week. So basically, because of the complexity of this one, we probably should have closer to 2 weeks, because it's not even only the review like it is with a typical traffic study and a few emailed comments between us and traffic ops and signals, but it's a lot of interdepartment meetings. I mean, we're meeting regularly with our DOT director to talk about this issue because it's so high profile. So this one, I would estimate we need additional time over and beyond the at least 5 working days, which we did not get for this one.
Thank you. And I'm going to direct this to our county attorney, just connected to this, but are there limits on how many times a case can be held?
No, there are not limits. It'd be up
Okay.
to whatever the board's discretion to do, so.
Okay, thank you.
Thank you.
Yes, we have another question. Go ahead.
I know this has been held quite a few times, and I can attest I've had some held over a year in my districts because of issues and meeting with the public and community. I'm not comfortable moving this forward either way until we have all the information in front of us and staff has had time to analyze everything.
Thank you.
Can certainly appreciate that sentiment too. I did want to ask the applicant a few questions though, just, you know, we are talking about an interesting scenario here where, yeah. Amy, I think you're off the hook here.
Thank you.
I'm sorry, one last clarifying question, Amy. Sure. The plan proposed, that is the intersection that DOT shared would be a better intersection at our last hearing?
Yes, I mean, there's no argument that came from DOT. The request to analyze it came from DOT. That's not what's in question. What's in question is the report implicates that it's a planned project by DOT and that therefore, you know, the funding issue isn't addressed. What our director's concern is, and rightfully so, is that they're going to build, and then if we cannot obtain funding for this project or approval for this project, then we've worsened the condition for a situation we already know is a problem.
Okay, thank you.
Thank you. Applicant? So we've got a few different questions. Certainly one hinging on DOT's point about the new design. And I know in my instructions in the last one, I had also discussed doing or we were looking at the original design, not the new design at that point in time, even though it had been etched, it wasn't necessarily presented. And so there was a request to make sure that the numbers were shored up and to do an analysis on the, at that time, proposed design. And so just curious if there had been enough correspondence with DOT to pull that, make that assessment to not do the traffic study on the original design and to only look at the alternative design.
Right, yeah, there was, and I think Amy stated it correctly, there was significant exchange of communication between the traffic engineer, applicant, and DOT. Number one, to ensure that it was understood and agreed upon in terms of the numbers, the student enrollment, about what was the study going to incorporate as far as a base model in terms of, I think it was worst case, or really it's not worst case, it's just that's the maximum allowed under the approvals, and ensuring that where students were being shifted from, because keeping in mind there's a middle school now, and so that middle school population would be moved to this property, and then there's some additional shifting. So it's just making sure that all of those numbers are accounted for, A, and B, that the maximum number that's allowed is accounted for as part of the study, as opposed to a different number. And that took a little bit of doing, but ultimately everybody came to the same page of the hymnal and said yes, and said grace over it, said yes, those are the numbers from a student enrollment standpoint to run the traffic study. And the traffic study was conducted on this alternative design that had been proposed by DOT as the traffic study that was submitted. And we did not perform it on any other pieces because as you might recall, the other alternatives had outside of, they weren't, DOT was not critical of the other studies because of the study itself, but critical for other reasons that said, that's not something, or that's not a solution we like. And that's what led them and what led DOT to propose this alternative design. So that's why we ran the study and had extensive communication with DOT back and forth on that.
Thank you. And with regards to, this particular development, is it the intent, considering that you've done this study on a design that does not exist today, is the intent that development wouldn't occur until this design is in place?
Well, the intent would be this proposed project for the middle school for this property is a minimum of 3 years away in terms of the schools, in terms of St. Benedict's timeline itself. So the intent is that that coordination can occur with the county to ensure that this either design is in place and coordinated appropriately. If you'll remember, we have a carpool plan that works for the existing configuration of the streets. That was stated by DOT last 2 months ago. It actually works, the carpool plan and the implementation of that by St. Benedict's. Where DOT's issue with that current carpool plan is they had a concern about private control on the public street and ensuring that could occur. They were uncomfortable with that aspect of it, and they had a reason to do that, which is why we moved to this proposal. But when you say what is the intent, yeah, that would be the intent, is that this could be done, and that gives us plenty of lead time for such a project to come to fruition.
Okay. And yeah, I think part of that is it can't be stipulated. It privately controlled, as you mentioned. Last question I have for you, it's kind of a compound question here. Regarding the submission of the traffic study on Tuesday, just some insight into the delay, and also if you can speak to not necessarily having a community meeting to keep everyone involved in what was happening there.
Sure. So first, like I said, this was a new traffic study because you're analyzing something that, a design that had just been proposed 2 months ago. So it had to be a new traffic study, had to be modeled off of new numbers that we agreed upon with DOT. So that takes time. I mean, just like it takes time for DOT, and understandably so, to review this and to understand it, make sure they can accept it or have comments or go back and forth with it. It takes that much time and more to put that together. I mean, it's a complex process to do these traffic studies. It's probably why they charge so much. But it's a real study that undertakes a lot of analysis and modeling that goes into traffic engineering, and that takes a while. It also takes a while to get that scope down, making sure that DOT and the traffic engineer and the applicant agree on what's going to be studied and under those numbers, and all of that occurred. As far as then going through that process, once that was done, we informed DOT that we would be submitting it on Tuesday, and they said to look forward to seeing it on Tuesday. Apparently, they don't have enough time to do the deep analysis on that, which is fine. We understand where they are with that. And so that's what was undertaken. Now, keeping in mind that we have a stipulation letter dated April 13th that hasn't changed. That site plan hasn't changed. Our stipulations and conditions and commitments haven't changed. The only thing that's added is our commitment for the $200,000 contribution and our commitment to work with DOT and Cobb County on this new design. That's it. So that's still, it's the same stipulations and conditions and project that have been a part of this all along. What we have been working on is to try to have at least an agreed upon analysis with Cobb DOT so that this board can review the facts of the case, both based on a traffic study that matches a proposed solution to the traffic issue. That study is accepted by DOT, and then the board can consider it. That's where we've been trying to get to. Now, the second part of your question relates to the community. So we've had community meetings that go back to 2018 and 19 on this project, and we've continually had those updated community meetings. We've continued to meet and talk with community members. Up till 2 months ago, when we presented the case as it then stood, that had community input into this stipulation letter, into these conditions or specific conditions requested by the community. Not all the community agrees with us. That's okay, it happens. But since that time, we have not proposed anything different. The only thing different that has come out of this is that the DOT proposed a new design, and we did a traffic study on it, which we submitted as a public record to the county, in which apparently they've had communications on outside of communications with us with DOT. So I don't see an issue with the community. I see an issue that some of the community is opposed to the project. But as far as community engagement, this has had more community engagement than I'm aware of any case in terms of that update.
Excuse me, Commissioner, if I can just follow up. 2 months ago, it was articulated by more than one board member a desire for a community meeting to take place. So I understand there have been a lot of community meetings, but there's an expectation that there would have been a community meeting over the past 60 days.
Sure.
And I'm a bit disappointed that there wasn't, in addition to having us be in the same situation that we were in 2 months ago without having a traffic plan being assessed. You know, as much as we want to work with the school, it's like Groundhog Day. We keep ending up in the same situation over and over again. And, I'm hoping that with what Amy has today, that it will be adequate for her to review. But I can't understand when it was articulated by more than one board member for there to be a community meeting, why one hasn't occurred.
I can tell you it's a matter of timing as well. Obviously, St. Benedict's is not opposed to community meetings. They've hosted multiple community meetings. In this instance, the new information is the traffic study on that new design,
Understood.
which needs to also have with it a DOT analysis of either accepting of the traffic study or accept it with conditions or however they want to do it. And so a matter of timing, we turned it in last Tuesday, because having a meeting without having DOT's analysis is meaningless, because you're going to have the community response of, well, what does DOT say? So you run into a chicken and egg situation about which comes first. What needs to happen is we've turned in the traffic study, which we have done so. When DOT gives us their comments and analysis, it can be revised or updated, and then we're happy to have a community meeting. We have everybody's email, we have everybody's communication, we can have one anytime. So that's,
Yes.
it became how do you do that? Before
Communication,
today.
yes, I understand. I just think communication helps, even if you didn't have the final, work product. Just having the conversation, I think, is a sign of good faith that you're trying to
Sure.
work with them. And so even just there being some communication that wasn't going to happen for that reason would have been helpful. It's just, I'm probably unable to conceive the amount of frustration that someone in the community may have to continue to come here meeting after meeting to have it held without having information in place and see things still not work in their interest. And I know we're trying to balance the interest. I'm just asking for your help in doing that, because I think we've been trying to be very patient because we understand the significance of the institution to the community, and we're trying to balance that with the needs of the community.
Absolutely. And to the community's point, there was a question that someone had asked regarding the congestion at Cooper Lake and Daniel. Does your traffic study also incorporate that part, or is it just the intersection around Atlanta Road?
No, it analyzes Cooper Lake, current intersection of Daniel and Cooper Lake and how it functions, as well as the new proposed intersection.
Okay, thank you. Those are all of my questions
Thank you.
for you. Does anyone else?
Commissioner Burrow.
On this GIS map here, the rectangle that is not outlined in yellow is not part of this proposal. is that where the road closure was recommended at Cooper Lake, at the end of that rectangle?
There was there have been a couple of different proposals. One was to close Cooper Lake coming south at our property, if that's the one you're talking about, as well as there was a proposal to put in a connection at Cooper Lake and Castile as well. Those were prior alternatives that were reviewed by DOT.
Okay, can you go back to the traffic plan slide? I'm trying to figure out if that piece is this vacant piece in the middle here where the road is being closed. Is that the school property?
I think Amy could answer that, because the way I would look at it is that would become DOT property, because we're closing a road there. Correct, Amy?
But this is the subject property in Daniel Street, and Cooper Lake, that goes up to the portion that you said.
Okay, so that's south.
It's
of-
further, this is further south of all of that. This is the existing intersection of Daniel, Cooper Lake, and then Atlanta Road here. And this
Okay.
proposed to be shifted to
So
this
that's not-
location.
That's not the same rectangle in the other.
That's correct. It's not
Okay.
the same.
So, the property that is not part of this proposal in the other map that was up, is that, would that make up the up to 5 acres?
Yes.
And have you looked at adding that?
Yes and yes.
And
It's not come to fruition yet, but I don't want to speak about private contractual matters as far as that goes, just from a confidentiality standpoint. But the answer is yes to the first question, and as well as yes to the second.
okay, I know we've asked this before, but, okay. That's- Thank you.
Thank you, Commissioner.
Any other questions?
Okay. Before I make my motion, I do appreciate everyone coming out for this particular hearing, and am hopeful that with this motion, if it passes, that we can come to a final resolution so that everyone is on the same page, that we all have the same information, and we're all clear on why a decision was or was not made, or why a decision was made, whichever way it goes. But with that, I am motioning to hold this with two requirements. And these requirements will be, I hope they will be honored. The first is that there is a completed analysis, the completed traffic study analysis on behalf of DOT with their recommendation. And the second is that there would be at least, at a minimum, of one community meeting, but certainly correspondence throughout the duration as there are updates, and that meeting would occur at least 1 week prior to the hearing. And at that meeting, there would be a discussion around the results of the traffic study and incorporation of any opinions from the community as well. I think that's all I have in my motion. 30 days. Oh, you think 60?
I'm going to say 60, and the only reason why is we know DOT director is out this week on vacation. We're coming into July 4th holiday, which means a lot of the community are going to be traveling. So in order for the applicant to meet these requirements that you have put here,
True.
60 days might be better for them to achieve them successfully.
Okay. And I was basing it off of Amy's request for 5 days, but the holidays on behalf of the community I did not consider. Perhaps I can have I don't know if I can have someone from opposition to just share with me that opinion on 30 or 60. Who can come up? 60 days is fine. And for the applicant?
However you direct, that's what we will do. We can make that happen. I certainly don't want to come back and not have the items completed. I'll put it that way.
Thank you.
Commissioner, maybe a week out might even be too close to the hearing date.
Yeah, if we do 60 days, can we make that at least 2 weeks before the hearing date?
Certainly.
Thank you. 60 days.
August 16th, we can do that.
Yes, August 16th. Thank you, Bill.
Second.
And that's for Z78. We're going to have two
For
different
Z78,
motions.
and I
Okay.
believe I'll have to make we didn't hear this, I don't think we did a motion to hear them at the same time.
Yeah, we did.
Oh, we did, okay.
Yes.
Okay, then yes, for a motion to hear that in 60 days with the same requirement. On
Does this motion
August
include both
16th.
slip-
We're going to
Slip-
finish 78 first.
Okay.
That motion was for 78, and then we can move into the next one.
Okay. That's my motion for C78.
Second.
Any
Thank you.
discussion? Call the question. The motion passes 5-0.
Thank you, Commissioner.
You can
And-
continue with your.
The motion for SLUP 11, thank you. For SLUP 11 to have 60-day held with the requirement of a completed traffic analysis and the community meeting at least 2 weeks before the zoning hearing on August 16th. And that, yeah, August 16th date.
Second.
Okay, so hold to the August 16th meeting. Okay. We have a second. Any further discussion? We'll call the question. The motion passes 5-0. Thank you. Commissioners, I need to take a 5-minute break. Thank you and welcome back to our Board of Commissioners zoning hearing. We'll now move on to our next case.
Thank you. Next case is rezoning case Z83 of 2021, St. Burke. Request a rezoning from OS and RM12 to RM8 for a townhome community and land lots 390 and 391 of the 18th District. Property is located on the north side of Mapleton Parkway, northwest of Honeycutt Road, and on the west side of Rioka Circle. The applicant is present. Is there anyone here opposed to rezoning case Z83? Two. Let the record show there's 2 people opposed. All those wishing to address the board, please come forward to be sworn in.
Good morning, Commissioners.
Good morning. Please go ahead.
Good morning. My name is Dan Mason. I'm with St. Burke. We're an asset management and development group based out of Atlanta.
Yes, can you speak up, please?
Yes, ma'am. Sorry about that. And I'm here today representing my client, Curley Family Homes. They're a local home builder here based out of Cobb County and build across metro Atlanta with single-family homes and townhomes. And so I'd like to go ahead and start the presentation here and talk about the project. It's off Mapleton Parkway. As you can see, it's currently zoned office and service, and portions of it are RM12. And you can see to the west, there is a Georgia Power substation with Georgia Power owning that property. And to the north is the easement, power easement going back to the east at the northern property. And along the east side there are homes bordering Rioka Circle. And then you can see to the south, the property borders Mapleton Parkway. So what we're asking for today is 38 townhomes on 8 acres. They anticipate the homes starting in the low to mid 300s, and size is starting right around 1,950 square feet. And as I mentioned, it's currently O office service and RM12, and we are asking it for RM8 proposed zoning. The current comprehensive plan calls for a medium density residential with a max density of 5 units per acre. And our current proposed plan has a density of 4.75 units per acre. And the facades will be front and rear alley loaded townhomes. There'll be townhomes that face Mapleton Parkway that will be kind of an alley loaded product. And then there will some other ones in the interior will be front loaded. The interior units will have a mixture of brick, stone, and hardy plank and cementous siding. All the units will have an individual sprinkler system for fire safety, and it'll be a small walkable community where you could walk across the entire community in about 2.5 to 3 minutes, so it'll be a tight-knit community. There'll be a central pavilion and lawn area with a separate dog park in the woods. The grounds will be professionally maintained and landscaped. There'll be a mandatory HOA, which will be responsible for the community maintenance, which will include the stormwater, the community entrance monument, the dog park, and the community pavilion, and all additional areas that are disturbed during development. There will be an additional enhanced landscape screening area outside of the 25-foot landscape buffer for Rioka Circle. That additional landscaping will be a mixture of evergreen, shade trees, and flowering trees. In addition, there's a decent amount of invasive English ivy that's on a lot of the trees in the existing buffer, and we will go in there and clear that ivy out. All the units will have a 2-car garage, and as an HOA requirement, you will not be able to use your garage for storage. You'll have to use it for parking to help with the parking situation that sometimes happens with these type of communities. The front-loaded garages will be at least 23 feet from the back of sidewalks, so we will not block the proposed sidewalks, which we'll have on both sides of the main drive, along with underground utilities. The trash pickup will be with individual units with no commercial dumpsters. All the units will be for-sale units, and an HOA requirement limit the number of units to just 4 units. So it's not a BTR or built-for-rent community. This is a for-sale community. The community will have an HOA, and it'll be responsible for enforcing the rental restrictions. And we'll also work with Cobb County Schools to provide a bus waiting area and it will be maintained by the community HOA. And the townhome elevations and landscaping will be in ordinance with the Mableton Parkway design guidelines, so we'll meet that criteria. We've offered to create a landscape review committee consisting of the owner or applicant or developer or property owner, along with a member from the Mableton Coalition and a representative of the Cobb County Community Development Agency. The committee shall be responsible for the overall landscape plan, fencing, buffering, and the Mableton Parkway frontage. We are asking for a couple of variances to allow all the roads within the community to be public. We're asking for a front yard variance to allow it to be 15 feet. And we're asking for a side yard of 10 feet, which would still allow for 20 feet between buildings. And we're asking for a side corner variance as well, down to 15 feet, and as well as for the rear alley to allow for those units off of Mableton Parkway for the larger roads, since we've gone ahead and changed everything out. At one time, we were looking to do some private roads, but we, at the request of the community, have changed everything out now to be public roads, so that will not be the responsibility of the HOA going forward. So that's the reason we're asking for these variances request. Another, I guess, big issue is with this area in general is the potential for blasting. Obviously we'll follow, if that does have to happen, obviously we'll follow all the state and county guidelines that are required for that. And one of the requirements for the county is potential an escrow in the amount of $50,000, but we are obviously willing to up that to $100,000. And so that would result, if damage were to happen, if we were to need to blast, that money could be used to go to the property owners if property damage should happen as well. The blasting companies also would do a post and pre-blast survey for all the homes within a certain radius, where they go in and actually videotape all the existing conditions of the homes and make sure that nothing changes as a part of their requirement for blasting. So they'll do a pre and post blast survey if blasting is ultimately required to be done during construction. These are the proposed elevations of the townhomes that will face Mableton Parkway. As you can see, they're a mixture of brick, stone, and hardy plank with covered entries and transoms above the front doors. This would be a section driving into the development, and this is kind of what that section would look like. The stoops on all the townhomes will be brick, and the side entry. We also, at the request of Commissioner Sheffield, have agreed to allow that side elevation there where you see the brick in the windows to be on a majority of the side of any basically side elevation that's visible from the street. So that's what those will look like. And here's an example of some of the other ones that will have a front-loaded garage that, again, will have a mixture of brick, stone, and hardy plank with different hardy plank textures. And so that's what I have for you this morning. As for now, I thank you for your time, and I respectfully ask for your support today. Thank you.
Thank you. With that, we'll hear from those in opposition.
Good morning again, Commissioners.
Good morning.
I'm Mary Rose Barnes, excuse me, speaking on behalf of several homeowners of Ryoka Circle, which is adjacent to the property, in opposition to this application. When C-83 first came up, I was asked to assist them in helping to protect their property rights in this matter. I've spoken to the Planning Commission 3 times and addressed the Planning Commissioners on several occasions regarding these concerns. Mr. Mason testified under oath at the Planning Commission meetings and at this hearing on behalf of Curley Family Homes, not the applicant, which is St. Bork. Curley Family Homes, the supposed builder, is not a party to this application, and therefore the applicant is not being represented at this meeting. Mr. Mason also stated that there would be sidewalks on both sides of the main street. The site plan does not show that. It was not referenced by DOT. Mr. Mason's requisite letters to neighbors contained erroneous information. His November 4th letter included a site plan depicting the property as a property that was not on the application, and his March 29th site plan did not depict the additional land or property applied for in the revision. All of the stipulation letters to the Planning Commission were submitted in Mr. Mason's name, not the applicant, on the behalf of his client, Curley Family Homes. And 2 of them actually referred to Curley Family Homes as the applicant. It is therefore unclear what entity should be held responsible for the wording of the stipulations, Mr. Mason, Curley Homes, or St. Bork. Neighbors have the right to know. Stipulation number 9 of Mr. Mason's June 15th letter is in direct conflict with the supposed site plan specific concept of the letter, as it references a possible change in the use of the part of the property on Ryoka Circle. Obviously, ultimate use of this land is a vital concern to the Ryoka Circle neighbors. These apparent misrepresentations are not mere typos or slips of the tongue. They call into the nature of the responsible party and the possibility of efficacy of the proposal, efficacy problems with the proposal. We believe that the decision made should be based on application by the applicant or his representatives at the meeting and in the letters. Ryoka Circle neighbors' concerns were initially largely based on the need for protection for themselves and their property in the event of blasting. Mr. Mason's admitted there's rock on the property. In his June 14th letter submitted on behalf of his client regarding possible blasting, failed to list notification of the neighbors or district commissioner, a blasting time schedule, limit of blasting hours, contact number in the event of damage or questions, or the coordination with the neighborhood community. But as the contradictions presented by Mr. Mason regarding the identity of the application, the actual size and shape of the track were brought to light, this evident lack of transparency became obvious. It is essential that entities choosing to promote developments in Cobb County be familiar with and willing to abide by standard procedures, provide accurate information to the public and the county officials, and consider the safety concerns of the community. On behalf of homeowners in Ryoka Circle, I respectfully request that your board deny this application. Thank you for your consideration for all these many months.
Thank you.
Good morning. My name is Robin Meyer, and I'm the chair of the Zoning Committee for the Mableton Improvement Coalition. I hope you'll excuse me this morning because my comments are probably not in any particularly great order, as we received the most recent site plan just yesterday. So I'm speaking a little bit off the cuff here. We do appreciate those changes made to the site plan, rotating the units at the northern end of the development. I don't believe we saw the site plan on the overhead. I don't know if you have a copy of the site plan, but that site plan that we have seen, we are comfortable with. We appreciate that the streets are public, that the Mableton Parkway design guidelines will be followed. It has been a long process. I think this is the 10th site plan now, but little by little we have gotten there, except on a couple of issues. We understand that there have been agreements reached about the detention pond on Rioka Circle, that it will have evergreen landscaping around its entire perimeter, and that there will be no construction access through that parcel for the remainder of the development. The only construction access off Rioka Circle will be for the development of the detention pond specifically. And then once the detention pond is in place, it'll be surrounded with a evergreen landscape buffer completely surrounded, all four sides. If the detention pond has to be accessed for maintenance from Rioka Circle, the access point will have to be screened with additional evergreen landscaping so that the gate area and the road area would not provide a viewpoint of the detention pond. This is important for the folks on Rioka Circle. This is a small neighborhood of 15 homes, and for all these years, those first two lots have been vacant lots, and now one of those vacant lots is not a new home, but a detention pond. So I think the best we can try to do in this circumstance is to make that detention pond look as much like the woods that they've been used to as possible. There are two issues that I do especially want to focus on. One has to do with shielding the homes on Rioka Circle from the cul-de-sac and the parking lot. I understand that there were two options offered by Mr. Mason yesterday, and of those two options, we prefer the one that moves the two parking spaces on the cul-de-sac to another location, with the final site plan to be approved by our district commissioner. And then the very last issue is one that I am pleased to hear we've made some progress on, although it is not contained in the most recent stipulations letter we've seen. Mr. Mason did promise just a moment ago to establish a escrow account for adjacent property owners who might experience damage as a result of the blasting. That is a request we've made for quite some time, and so we're pleased to see some progress on that matter. The amount that we would like to see for that escrow account is $150,000. We reached that amount by multiplying $10,000 times the 15 homes on Rioka Circle. One of these homes is within 66 feet of the property line of the property that will have the blasting, that might have blasting. And as described to us by Mr. Mason, the area that has the highest probability of needing blasting is immediately adjacent to the property line on the Rioka side of the property. So not only are the homes on the western side of Rioka Circle quite close to this, but even on the eastern side of Rioka Circle, the concrete driveways of those homes are only about 220 feet from the area that might be blasted. As a resident of this area, I can tell you that we're pretty much all sitting on the same big piece of rock. As neighborhoods have been developed around me on Queen Mill Road in the time I've lived there since 1984, when blasting occurs, it's not you know it's going on, you know it's happening. And I've never been as close as these homeowners are going to be, and I think they deserve all the protection that we can afford them. I've sent you citations to your county ordinance that provides for that escrow amount. I think it's clearly within your power to require it. It's my understanding that it's put up by the blasting contractor, not the applicant, not the property owner, not the developer. But I leave that to you all to tease out the details. So again, we would recommend approval of this application with these details handled. Thank you so much.
Thank you. All right. Seeing no additional speakers, I'll turn things over to you, Commissioner.
Thank you. I'll start with Amy.
Amy Diaz, DOT.
Hi, Amy. With respect to, excuse me, with respect to the sidewalks, did you review and did the analysis include the 4 feet sidewalk and for the development standards?
So I did, the lines on the drawing are obviously very small, and the ability to scale between a 4-foot and a 5-foot sidewalk on that scale of drawing is pretty much impossible. If they are planning a 4-foot sidewalk, I would say that is not recommended. Basically, ADA recommends a 5-foot sidewalk. So to address the Americans with Disabilities Act, we recommend 5-foot sidewalks at all public street locations.
Okay. And on this plan, can you identify the sidewalks for us, please?
Okay, well, that's very difficult, but I can try. Yeah.
Okay.
All right. How do I zoom in? Zoom into like the Mapleton. All right, the easiest way to find where you are for a sidewalk is to follow it from the main street. So if you see here, you've got this double line here and this line here. That's your sidewalk, and you're curving into the site. It stops here at the driveways, presumably because the driveways basically have a sea of pavement until you get to the next little section here, which connects to those two. Then again, you have nothing but driveways, another section here, and then it starts here, comes out, comes through here, and stops.
Okay, and then on the other side?
And then on the other side, again, following from the roadway, you come up here. This one is a little unusual. It has a sidewalk that comes along the front of the buildings because they're backloaded.
Right.
And then you do have the sidewalk that goes up to the corner. And then looking at the other side of the street, you have this sidewalk, and it comes into the parking area, comes through here around the mail kiosk, and through here, and stops at the driveway. And then you also have a sidewalk here, coming on the other side, through there. So.
Okay, so with respect to the areas where we don't have sidewalks to the west of those units, is that primarily because of the length of the driveway?
Right, that is my understanding. This is all obviously very conceptual. Like, one of the things, just looking at it, that the ramps would not be lined up correctly if this line was correct, because you have to line them up parallel to the intersection. So there are details in plan review that we would make sure happen. But as far as conceptually, from what I can tell, they have put sidewalks on these plans.
Okay, all right, thank you. That's all I have for Amy. Do you guys have any follow-up questions for her? No? No, okay.
Thank you.
I'd like for Josh to come up, please. Josh, I'd like for you to talk to us a little bit about blasting. That is a concern for the community, and I have some stipulations that will address the blasting. But if you can talk with us a little bit about it, and reviewing the county code, there is a number of $50,000 that an applicant may be required to pay into escrow. And I was just wondering where that number, what was the calculation in arriving at that $50,000 number, if you are aware?
I couldn't speak to that. I'm not sure where that number came from, but I'm sure it's there for if there is potential damage that could come in or that could be done. They can use that money to pay for that damage, I think.
Right, yeah, I know what it's for. I was just curious to know why 50,000, why not 25, or even why not
I'm not sure, just
75 or
an
100?
arbitrary number.
Okay, all right. Can you explain to us a little bit about the blasting process?
So what they have to do is they have to apply for a permit through the county. I know the police department, the bomb squad also looks at the application. We look at it as well, making sure they have their current insurance, their map of the blast site, making sure they have the current licensing for blasting and from the federal and as well with the state.
Okay. And what about how the actual blasting occurs?
I'm sorry?
How the actual blasting occurs? Are you familiar with how it occurs, the blasting itself?
No.
Okay, all right. I did a little research over the weekend because in my mind, when I heard blasting, I just thought about a whole heap of dynamite sticks and just kind of just throw it in. But actually, it was pretty interesting. So the blasting, it occurs with engineering blasting agents with ammonium nitrate, which is also used in fertilizer. And the top portion of the rock is filled with the ammonium nitrate material. And on top of that, you have sand and stone that's placed on top of that. But essentially, let me just go back a few steps. Holes are drilled in the rocks at fracture points, and then it's filled with the ammonium nitrate. Sand and stone is on the top, and then the blasting occurs. But the reason the sand and stone is on the top is because it keeps the gases, the released gases in the rock for more effective blasting results. So I just thought I needed to do a little research on that because in my mind I'm thinking, it was probably a lot more impactful than, and I'm sure it still will be impactful, but this helped me a little bit with that. There are a fair amount of state and even county regulations as it relates to blasting, but as far as fire and public safety, do you guys visit the property in advance of any blasting?
If the blasting is going to be close to structures, we could require that. We can also require like a pre-blasting survey and a post-blasting survey of the structures that are within, I think it's 1,000 feet of the blasting site. So.
Okay, all right. That's all I have for Josh. Do you guys have any questions regarding blasting or anything for Josh?
I do have a question. Is there a minimum distance for blasting near a residential property? Some of these properties look close to where this site is.
I don't believe the code says anything, a minimum distance from a blast site, but and I'm sure if it's pretty close, they'd have to, get engineers involved to see how that's going to affect a structure that's close to the blast site. So there's nothing at minimum.
Okay. Yes, and for the applicant, I know when the applicant comes back up, I know you're here now, just related to this, I'm curious to know if there is a plan to assess all of the homes that are to the west of Ryoka Circle. And I see the applicant nodding, okay.
Yeah, he mentioned that, but we can bring him back up. Do you have a question?
He nodded, so I'm good. Thank you, Commissioner. I got it.
Well, I was going to try to offer some assistance, and then actually, I do have a short video of blasting that went on in a neighborhood in my subdivision.
Okay.
If you want to kind of see what a blast looks like, we could put it up there real quick. It's only about 10 seconds.
Okay.
But this blast, just for reference, was about 75, 100 feet away from existing homes. All those homes were inspected prior to the blast, and none of them received damage from this blast. So if you would like me to show it, if
Sure,
Cynthia
I mean, I'm
that
sure.
way everybody can kind of see what a
I
blast is
think that would
like.
be helpful in those that may be observing from home. Looks interesting. Would love to hear some sound, but it's less impactful as. Proceed.
But, obviously.
All right, I'll just imagine. Okay, well, it's good to see that, the trees weren't impacted. Thank you, Commissioner.
May I have the applicant to return, please?
And Chair, just to answer, I was on site when this blast happened. We were standing just outside the safe zone. It kind of sounded like a rumble of thunder. You barely kind of felt the ground shake. It was, I hate to say, uneventful after what we all tend to expect. But as far as a lot of noise, it wasn't.
Thank you.
What I've been told is, oh, sorry.
That's okay. If you would, with your pointer, and I understand that there might not be a need for blasting on the entire site, but if you would, please just point to the areas where you propose there to be blasting.
If there could potentially be some in here. There could potentially be some in here.
Okay.
And there could potentially be some down through here with a sewer line.
Okay.
That's,
So and I don't know, you might not know this, but how far east would you propose that there might be blasting?
40, 50 feet off the line there, off the property line.
Okay.
At 40 it would be the closest.
Okay.
But
So
that's,
for the
again,
nearest
that's-
home, that's approximately 100 feet.
Yeah,
in
and that's,
the
I'm still kind of guessing there because, again, I don't know for a fact where that sewer line is going to be once it's engineered. I'm just kind of guessing.
Okay. All right. Thank you. Thanks. Does anyone else have questions for the applicant?
I do, yes. Can you clarify who you represent?
Yes, ma'am. So I'm here on behalf of Curley Family Homes, and on the we filed the application, St. Burke Development Group, and so we will develop the property for Curley, and we will then they will use the lots to build the build the townhomes.
Thank you.
Was there anything else? Anyone else have questions?
Yeah, go ahead. Do you have a
The site plan, is this the site plan that was received yesterday?
Okay, so let me get.
Sunday night?
Okay, so zoning received the site plan on the 16th. They had to revise the site plan. There's been a little bit of back and forth, so I have an amendment, a stipulation that I am going to approve the final site plan. But what you're looking at right now was the site plan that he submitted on yesterday.
And what's the
Go ahead.
what's the total number of units?
38.
It's the same,
Okay,
38.
because I
38.
think in the book it still says 53.
53? Do
Well-
you have the updated information?
No, I don't have that site plan.
No, but it's
Okay.
been reduced to.
And that is, you said under 5 units per acre?
Yes, it's 4.75 units per acre. is
And
the
you're
density.
asking for RM8 still?
Yes, ma'am.
Okay, why not RA6 or RA5?
Do you have additional questions?
No, I mean,
Okay, all right. Yeah.
This is kind of a comment and a statement. So if we're having to blast along this whole western portion, the applicant is also asking for significant variances on the front side and rear of this development. So my question is if blasting is a concern, why not do the front setback variance? That way you don't have to do all this additional parking that is here in the center, which would potentially eliminate a lot of blasting. So I guess my question would be is what would the site plan look like if they did it to code without all the variances, without having smaller streets, that's, again, driving the extra parking requirement?
And John, I'll ask you to jump in, but the parking is going to be required. I don't know that we can reduce any of the parking that we have here, but John, I'll allow you to share your zoning analysis on that.
And Commissioner Sheffield is correct. You know, the parking in the first set of plans or proposed plans, it was not centrally located. It was kind of either on the north or south sides of the property. So where the parking's shown, where that number 27 is a result of them revising the plan to meet the fire marshal and DOT and the zoning requirements that it be centrally located. So that's why the park is located right there, Commissioner.
But isn't it also required because they've reduced their front setbacks and they can't park the vehicles in their own driveways?
That's also a requirement, but it chiefly comes from the fire department requirements that they have 0.5 guest parking spaces per unit. And there's no way that they can get a driveway on here that's long enough to accommodate cars in the driveway. Because they are showing a 15-foot front setback, and I think the requirement is 22 feet.
When I was looking it up, I thought the front setback was 40 feet, but not 22. I mean, they're saying that they've got a front setback of 15 feet.
The front setback is 15 feet, Commissioner, but the length of the driveway is not much more than that. So I don't think they can get an entire car parked on the driveway without it sticking into the right-of-way.
I'll just say, Commissioner, that to have the roads be public roads, I think is a good trade-off versus having the community having to pay for it if they were private roads. I think I overheard the applicant share that was a consideration for that.
Right.
And for 38 units, it's a pretty low number of residents to have to maintain that.
Precisely, yeah.
So would the county be responsible for maintaining their additional parking area, or would that be left to the HOA?
That would be for the HOA.
Sorry, give me one moment. I wrote down. There were some questions with respect to screening of the detention pond. I don't know if you're going to address that in your stipulations, okay? And also, for the applicant, is the access point to the detention pond going to be that parcel that's purchased off of Ryoka Circle?
Yes, we, for maintenance, for maintenance, I don't know that, today, I don't know that I can tell you that there's a large grade change from where the townhomes are to where that detention pond is. So I think the best way of access for maintenance will come off of Ryoka. But it would just be for, you know, a monthly maintenance or whatever's need to do it. We'd also need to, you know, obviously maintain our frontage so it doesn't look abandoned and wild. So that looks nice. So, and I think, you know, today that area is a very low depressed area. And I think that's part of the reason there's never been a house built.
Yeah,
So.
okay. Okay, thank you. I don't have any additional questions, Commissioner.
Anything else?
Commissioner Richardson, did you have a?
Nope.
Okay.
Okay, you may be seated. I'd just like to thank all of the parties involved in the zoning process for this application, including Mid-County staff and our planning commissioners. There's been several site plan iterations submitted to comply with the desires of the community, and I appreciate the collaborative efforts between the applicant and the community stakeholders to ensure quality built development. With respect to blasting, I understand that the applicant will submit a pre and post blasting report, which I will stipulate, but I also recommend that the homeowners adjacent to the development also take photographs or perhaps even videos of the interior of their homes. And with that, Madam Chair, I'm prepared to make a motion. And this may be a little lengthy, so please bear with me, everyone. But I make a motion to approve rezoning Z83 to the RM8 category with the following conditions. With respect to the stipulation from St. Bork dated June 15th, I propose to amend the following. Stipulation number 2. The property shall be rezoned from OS and RM12 to the proposed zoning classification of RM8. The zoning shall be site plan specific to the zoning plan by St. Bork dated May 27th and revised on June 20th, 2022. A copy of the site plan is attached with this revised stipulation letter as Exhibit A. The final site plan is to be approved by the district commissioner. Stipulation number 5 of the June 15th letter. At the end of that paragraph, please add that all end units that face the street or open areas should have side elevations as reflected in the rendered marked end unit and left end unit fronting Mableton Parkway that was submitted on or about March 14th, 2022. The final elevations are to be approved by the district commissioners. And Commissioner, that's what I just... Oh, I'm sorry, district commissioner. But then I said commissioners, that's what I handed you guys for reference, and also the county clerk. And that's the photograph at the very bottom of that page. To revise stipulation number 12 of the June 15th letter, to include at the end of the paragraph, any dead or damaged plant materials will be replaced within 90 days of planting. These trees shall be planted outside of any utility easement. The final landscape plan is to be approved by the district commissioner. Paragraph 14. Okay. Please add to the end of 14. Escrow agreement to be coordinated with the applicant, blasting contractor, and the county attorney's office with the final approval of the agreement made by the district commissioner. Additionally, an escrow amount in cash should be submitted to the county in the amount of $100,000 prior to the issuance of the blasting permit. The sole purpose of this escrow agreement is to compensate property owners for damages, cosmetic and structural, to their property resulting from the blasting activity. The applicant is required to submit a pre- and post-blasting report and analysis. Further, the applicant is required to mail letters of any anticipated blasting to the neighboring parcels, homeowners, excuse me. Stipulation number 17, strike the word requirement and replace it with restrictions to read, All units shall be for sale units. There shall be no more than 4 units being leased at a time. The community HOA shall be responsible for enforcing rental restrictions, not requirements. Paragraph number 18 should read, landscaping, stormwater facilities, community interest monument, dog park, community park, pavilion, parking lot, detention ponds, and all other common areas will be maintained by the HOA. At the end of paragraph 19, please add, there shall be a 6-foot black vinyl clad fence and 6-foot landscape visual buffer of evergreens around the perimeter of the detention pond. And for clarity, the fence and the landscaping is to be around the entire perimeter of the detention ponds. Paragraph stipulation number 21. Please add at the end of that paragraph, the entry monument to have wired up lights and landscaping that will be maintained by the HOA. Number 23, please add at the end of the sentence, and maintained by the HOA. The paragraph should read, a school bus waiting area for children and residents shall be provided and maintained by the HOA. And I also like to include the following. No construction access from Rioka Circle except for building the detention pond or for stormwater infrastructure access. The Rioka Circle detention pond access is allowed for maintenance only. No construction parking on Rioka Circle or Honeycutt Road. The detention pond gate is to be located on the northwest corner of the detention pond, and that's the detention pond on Rioka Circle. Any other variances are to come before the Board of Commissioners as an other business item. The parking, shift the parking spaces from the Rioka Circle cul-de-sac to the location adjacent to the pavilion. And finally, all other staff comments and recommendations not otherwise in conflict.
Thank you, Commissioner. And you stated that in the form of a motion?
Yes.
Okay, is there a second?
Second in discussion.
Yes, go ahead, Commissioner.
John, are the setback requirements different for an RA5 or 6 as opposed to RM8? And if they're agreeing to a maximum of 5 units per acre, and they're at 4 point, I think you said 1.7, why are we asking for RM8?
And Commissioner Burrow, to answer your question, you know, the board can delete it down to RA5 or RA6, so the category that the board best thinks suits the property. The reason why they're at RMA is because that's where they started. When this started last year, this was RM8 for close to 8 units per acre with private roads. You know, as a result of their communications and conversations with neighbors and the commissioners and staff, they decided to go from private roads to public roads, which caused a lot of your setback variances on the interior of the subdivision. If they were still private roads, that wouldn't have happened.
Okay, but are the setback requirements different? And would they need a variance if they went down to RA5 or RA8?
They would still need variances for RA5 because the front setback for RA5 is 20 feet on an interior road, and I think they're showing a 15-foot setback on an interior road. The corner side setback is still 25 feet, whether it's RA5 or RM8 with public roads. So they
Okay.
would still need variances.
And Planning Commission recommended approval and staff
Correct.
at the RMA?
Correct.
Okay.
Just in follow-up, I mean, to her point, if it's being developed at a lower density, nothing materially changes if it's zoned RM8 because the density's still less than 5 units per acre.
That is correct.
They can't add a unit.
They
or
can't come
do
back and do 8
Because the site
tomorrow.
plan's specific.
And, you know, another reason why the staff recommended RM8 is because this area has a mixture of every zoning that you could think of in the zoning code. It's got R15, R20, RA4, RA5, mobile home park,
RM12.
RM12 right next door. I think it's got a couple of commercial categories too near the road. So it's got a bit of everything in it.
Okay. It's an interesting observation, though.
I mean,
To be zoned at a greater intensity than what it's being developed as.
right, because you think of RM8 as allowable 8 units per acre, and they're half that. I don't see, if we're making it maximum 5 units per acre because of the MDR land use category.
And this is an MDR? Yeah, that makes,
And you said there's RA4 and 5 and 6 in the area too.
That's right.
It just looks like they would be allowed to have 8 units per acre, even though they're agreeing to RM8 at maximum 5.
Well, if the board wants to delete it to RA5, subject to all Commissioner Sheffield's conditions, then that'd be fine also.
But, well, that's up to her, but.
But, and the reason it was down to RM8 is because it started out with more than the 38 units, which I think you had in your book. Yeah, and somehow, I don't know, the planning commissioner still continue to, and staff continue to move forward with the RM8.
That's correct.
But you mentioned with respect to the setbacks, that there would be no difference in the setback with RM8 versus RA5.
There still would be variances required for setbacks.
Right. Yeah, and that's what I mean, that there's no difference. It would still be the same.
That's
in
right.
terms of their ask for.
That's right.
Go ahead, Commissioner.
But would the variances be the same, right? Because the extent of the variance, okay, okay.
Well, you said that 20 feet was the requirement for RA5.
That's right.
And on here, it's 40, but they're asking for 15.
That's
So they
correct.
still wouldn't meet it, but they'd be
There will be a
closer than they
difference.
are
I
now.
agree. It's a
But to your point, you had mentioned that it's a trade-off for the public streets versus
Private, right.
they originally came in private streets, so.
I'm
I just-
repeating what I believe I heard the applicant say, but I always know I do appreciate roads being built to public road standards.
Yeah.
So is the concern that the variance intensity would be decreased, so where it'll be 20-foot setback for RA5, it would reduce the length of the setbacks that they're asking under RM8?
It would lessen the setbacks. They would still need setbacks. I think deleting it to RA5 or 6 would help allay fears of the board of then coming back in the future, wanting more units.
Yes.
I see.
Through maybe even a different board in 10 years.
Right,
So
I
if
see.
we done
I see.
RA5, then it's set at 5.
I got you. Okay. All right, good. Okay, that's a good point. Yeah.
Just one question on the 25-foot buffer. Is that to remain undisturbed in perpetuity? My only concern is that they only have a 10-foot backyard and then a 25-foot buffer. What's going to prevent those homeowners from taking those trees down to expand their backyards?
Well, it is a 25-foot buffer, but I don't think that it's in perpetuity, but there's also a landscape variance to add additional trees.
Okay, but while I understand they are adding trees, is there anything to make sure that those trees stay there in perpetuity, or can the homeowners go in and take them out?
The homeowners on Ryoko, you mean?
The homeowners that will
The new
be in this development.
Okay, I see.
Because again, the backyards are only 10 feet, and if you're anticipating kids here, 10 feet is not a lot of space to give for kids to play.
I see.
And do everything. So what is going to prevent homeowners from taking out that 25-foot buffer that has been put in place?
Let me take a quick peek at the,
Is it construction buffer?
no.
It's a landscape.
Can we see the site plan?
It's a landscape buffer.
Is the site plan?
So part of, there aren't, let's see, 1, 2.
Yeah, there it is, yeah.
Yeah, there it is. Okay, good. So to your point, Commissioner, the 25-foot landscape buffer, there are no houses that back adjacent back up to that buffer, with the exception of maybe those to the north of, a little bit north of the property of the development, near the stormwater pond? Is that the concern?
And then on your left-hand side, those are going to be adjacent. Granted, it's not really developed right now, but it will be developed in the future.
Is that the Georgia Power location?
On the
On
left-hand
the
side.
left-hand side?
Are you saying to the west of the development? Because that's the Georgia Power easement, if that's what you're referring to. Yeah.
So, Commissioner Burrow, you do make a good point in reducing it to RA5, just for the future development of the property to ensure that there aren't more structures than what the space can probably withstand. So, I would amend, John, can I amend the motion to reduce it to RA5?
To delete it.
To delete it, I'm sorry. Okay. Uh-huh, to RA5. Yeah. Thank you.
All right, we have an amended motion. I can't remember who seconded that motion. Okay, you comfortable with seconding that amendment?
Do I need to,
With that
can I
deletion
just
to
read it
R5?
for?
Okay. Can she go ahead and amend her motion as is, Bill?
Well, technically, after the motion is made and then there's a second, it belongs to the entire board. So as long as there's consensus among the board to accept it, then that's all that needs to be done.
Okay, is there consensus for her to amend it? Okay,
Okay.
thank you.
All right, thank you. I make a motion to delete RA5 with, hold on, let me, sorry. Yeah, let me just get my notes. I make a motion to approve Z83 to delete it to RA5 with a maximum of 5 units per acre.
And all the other stipulations from before. And I
Okay.
will second.
Do I need to repeat that again for the
Just
staff
all other
recommend? Okay. With all of the staff comments and stipulations not otherwise in conflict,
And all your previous,
and all my previous stipulations.
Is that clear? Okay.
The only suggestion I would make is we know that the density is 4.75, so I would approve it at an RA5 at a density of 4.75, not 5 units per acre, because then again, you give that wiggle room for additional units to be built in the future with it going up to 5.
Well, that's the maximum. That doesn't
It's the
mean
max
there
of
will be
5.
5 units per acre. But
I'm okay with leaving it there. Thank you, Commissioner.
Okay, we have a motion and a second. Any other questions or comments? All right, we'll call the question. All right, the motion passes 5-0. Thank you.
Okay, Madam Chair and Board, before we move on to the next zoning case, I did get word that the applicant for other business, item number 22 of 2022, Robert and Rachel Kerr, would like to continue their case into your July hearing.
Give me 1 second, John.
they would like to what?
Continue other
This
business
is in
22.
your district, Commissioner.
And it's my understanding that the applicant has worked with the civic group in this part of the county, and they're agreeable to continuing the case also.
Okay, I'm seeing head nods, motion to continue, or approve it. How do I do that? Because it's not a hold. Okay,
Motion to continue.
motion to continue the OB 22 to the next zoning hearing.
All right.
Second.
Any discussion? I'll call the question. Motion passes 5-0.
Okay, thank you. Okay, next case is rezoning case Z32, Amadeus LLC, request rezoning from GC to NRC for a commercial kitchen offices, a warehouse, and event space in land lot 637 of the 16th District. The property is located on the west side of Canton Road, north of Westerly Way. The applicant is present. Is there anyone here opposed to rezoning case Z32? Let the record show there's no one opposed.
Ladies and gentlemen, good morning. How are you today?
Great, how are you?
I'm excited to move my company into the Canton Street corridor, be part of Cobb County. We've been in business for approximately 27 years successfully. We support local communities. We sponsor local sporting events, local sport teams. During lockdown, obviously, we assisted in feeding the first responders, as well as the school children who are out of school and in need of lunches. We even served the quarantine over at Dobbins Air Force Base right down the street from here while they were on lockdown. So we'd love to be a part of the community with your approval of the rezoning. If you have any questions for me.
Thank you. You have 9 minutes left. We can reserve that. That's probably one of the quickest presentations. Are there others in support of this application that desire to use some of the balance of that time? Okay. And yes, we are unsure if we got your name at the beginning of your
I do apologize for that. My name is Andrew Brackner with Talk of the Town Catering.
Andrew Wagner.
Brackner, Brackner.
Thank you.
Yes, ma'am.
All right. Carol?
Carol Brown, Canton Road Neighbors. Very happy to see Talk of the Town Catering come to Canton Highway. This is exactly the kind of business that we welcome and like to see come. They are basically in agreement with our stipulations that I submitted in a letter dated June 1st. And I would want to, with the exception on my stipulation letter dated June 1st, I would want to go to number 8, hours of operation. And I had Monday through Saturday, 7 to 7, and Sunday, 12 to 5. But I would like to give them the latitude to request what hours they need and delete that number 8, because they are rather a unique type of business and may need special consideration for their hours. Does anybody, do you want me to read my steps into the record, or do you have? Will that suffice? Okay. Do you want to talk a little bit more about what you do, including the promotional events that you have?
Of course,
to explain?
Yeah. Again, I apologize. I haven't went for rezoning before, so I'm a little nervous. I don't have much experience in this. So we're a catering company. We do off-site catering. We have a commercial kitchen, a storage area for all of our equipment, like tables and chairs, shaving dishes, totes for beverage napkins, sodas, things like that. Our commercial kitchen can operate at any hour of the day or night, but again, we're inside, so we're not much of a disturbance outside by any means. Our offices, we probably have about maybe 10 offices total for our executive committee and supervisors. We go all over the entire state of Georgia. We went down to the Masters recently. We were there for 10 days doing catering. We go up to the North Georgia mountains. We go down to downtown Atlanta. Again, we're just an off-site little catering company. We do have a small tasting room where we'll host small events up to maybe 10 people for executive committees if they're looking for a decision for a large event. We host private tastings for wedding couples, for corporate events. And it's just more of a receiving room. We have a showroom where we'll set up different displays, different decor, so that way they can see the linen, decide on the color of this, decide on the type of plates and glassware, and we can basically just show them who we are and win their business.
Thank you.
Certainly.
Appreciate it. Are there any other persons that desire to speak in support of this application? All right, seeing none, again, I'll ask to see if there's anyone in opposition. All right, seeing none, I'll turn things over to you, Commissioner.
Okay.
Thank you. You can have a seat, sir.
Well,
unless
I
you have
have some
questions.
questions.
Okay.
Yes, ma'am.
If you could stay a minute. So the event center, is it for large parties or is it for corporate small gatherings or what will you be?
No, that's more of our tasting room where we could have 10 people show up just for an executive committee decision on a larger corporate event.
Right.
And every once in a while, we do host open house tastings. For instance, we partner with a few venues. And so the venue will say, hey, we have 20 weddings coming up this fall. Would you mind hosting a tasting for us? And so we'll have the people come into this area right in the front, adjacent to the offices. Well, again, it's our showroom. And so we'll give them a taste of our food, butler passed items, maybe a few action stations, and just kind of let them decide on the menus that they're going to have.
Right.
So it's not going to be
Like a wedding or?
No, we don't plan on
You don't
hosting
do
any
weddings?
weddings at all.
Okay.
No. That'd actually be that would be a bit of a conflict of interest with some of our partnerships that we have.
No, I mean a tasting for a bride to come in to see what she would want you to cater for her.
Correct, yes, just tasting, but not the actual wedding.
Right. No, I didn't mean the actual wedding, because you don't have enough space for that. But, and are you relocating, or is this a new office? A new
Relocating.
center?
We've been in downtown Roswell at
Mhm.
Canton Street and Woodstock Street for about 27 years now. I recently acquired the company. Well, I say recent, it'll be 8 years that I took over the company. I was the executive chef for about 7 years prior to that.
Okay. And so we're glad you're coming to Cobb. You have read the stipulations and prohibited uses that Ms. Brown submitted?
Yes, ma'am. Mhm.
Okay. So your hours of operation, do you come back after an event that you cater and have to clean up at your site? So
we
it could
do-
be late at night?
We do. It's usually between 11 o'clock, between 9 o'clock and, say, midnight at the latest. The vans will certainly pull into the back area, and they walk away. They get in their vehicles and they leave the property. The next morning, our warehouse employees will take the vehicle, open it up, take out the equipment.
Okay. So for your hours of operation, are you agreeable to Monday through Saturday, 7 a.m. to 11 p.m.?
Well, I believe she said she'll give me a little bit of...
I'm asking you if you're agreeable to that.
I am. Again, we are going to be operating sometimes outside of those hours, but in a very limited capacity inside the building, not making a disturbance outside. We won't be having people come in through the front door. Won't be.
You won't have customers coming in after 11?
Oh, no, definitely not.
It'll
No
just be
customers.
cleaning up or?
Correct. For instance, we have an overnight baker who she arrives at 10 p.m., 11 p.m., and she's there inside of the building until her job is done, maybe at 9, 10 o'clock in the morning, and then she leaves for the day.
So that would be an hour of operation, wouldn't it?
But it's not open to the
So do we
to the
need to
public.
limit? Do we need to limit? What about Sunday? I mean, you have events till late at night on Sunday, I would think.
Correct.
So, maybe if we restrict the hours, it wouldn't apply to employees inside, but it would apply to anyone from the public coming in or a tasting going on after 11.
Correct, yes. We don't have any guests. The latest we've ever hosted a tasting was 7 p.m.
Okay. So I would make it 7 to 11. And what about Monday through Saturday and Sunday the same or?
Sunday, we rarely host a tasting on Sundays, just due to people's schedule. It's usually during the week. We do have some Saturday tastings, but we never have tastings on Sunday. It's just a company policy. We never had a need to.
Okay. So would you be okay with Sunday from 11 to 6?
Yes, ma'am.
And do you serve alcohol at this location?
No, ma'am.
Okay.
We don't buy, transport, or sell alcohol.
Okay. So that would be for events to take place during those hours. You'd be restricted.
Yes.
But if your chef or employees are in there working, they could be in there at any time.
Correct. That sounds great.
You good, Ms. Brown? Absolutely. Okay. All right, I will make a motion to approve Z32 with the letter from Ms. Carol Brown dated June 1st for the record, and with the revised hours of operation for public, Monday through Saturday, 7 to 11 p.m., and Sunday, 11 to 6 p.m.
Is that the end of your motion?
Mm-hmm.
Okay.
Second.
All right. Any discussion? Do we need to add staff comments not otherwise in conflict?
Yeah. Staff comments and recommendations not otherwise in conflict.
All right, I'll call the question. Motion passes 5-0. Congratulations.
Thank you very much.
Okay, moving into the other business agenda. First item we're going to hear today is other business item number 25 of 2022, which is to consider a stipulation amendment for B&J Appliance Repair LLC regarding rezoning application Z32 of 2011 for property located on the west side of Austin Road, south of Pet Mill Road, in land lot 85 of the 17th District. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 25? Let the record show there's no one opposed. Would the applicant please come forward to be sworn in?
Good morning.
Yes, please go ahead, sir.
Yes, I'm asking that the commissioner give me permission to open an office at the location. There was a stipulation sometime in 2011 about I had a thrift store, and that thrift store no longer exists there, so I'm just asking for an office for my business to be put there. I need a physical location. We're not working on appliances there. We wrote appliances workers, so we just opened up an office in that building.
Okay, sir, can you state your name for the record, please?
Excuse me, yeah, my name is Sam Baskin Jr.
Okay. Thought you looked familiar, Sam.
Beg your pardon?
I thought you looked familiar.
Yes.
Several years ago. Very good.
So if you have any question, I'll be more than happy to answer them.
All right, thank you. Does that conclude your presentation?
Yes.
Okay, thank you. John, what's staff's recommendation?
Madam Chair and Board, the staff would recommend the Board of Commissioners approve the request, subject to the site plan contained in the other business packet, subject to no outdoor display of merchandise, Cobb DOT comments contained in the other business packet, stormwater management comments contained in the other business packet, fire department comments contained in the other business packet, and all previous conditions not in conflict to remain in effect.
Thank you. Commissioners?
Hello.
Hello.
I have a couple of follow-up questions for you, a couple of questions. Would you happen to know the square footage of the space?
Yes, the building is 1585.
1,585 square feet. And it's currently used as a thrift store. Is that in operation? Is that currently in operation?
No, the thrift store closed in 2013.
Okay. All right, so I can skip the next question. And you might have mentioned this in your presentation, but what is your desire to change the use?
Just for an office space, my desire is to just, most time when you're doing business, you got to have a physical location, and it can't be a post office or nothing like that, postal number. So you have to have a physical site in order to order parts and things that has to be shipped there. for us to go and take care of the customer business in their homes. So I need a physical address.
Okay, and so that I'm clear, are you planning to have appliances delivered at this location? Or is it just for purposes of having a physical address and having parts delivered?
Just to have parts and just have a physical address.
Okay, but
Not-
no.
no, we
No
don't-
appliance?
No.
Okay. And you mentioned a home office. You're not planning to reside at this location?
No,
Okay, I was a
no.
little uncertain about that. It was on
No.
your application.
No.
That you needed a home office as well.
When I mention home office, it's just, that's where our office will be at that location.
Okay. Also, in reviewing the past stipulations of September 2011, there was a requirement to install a 6-foot wooden fence along the northern property line. Has that been installed?
No, my neighbor, right in the area that it was supposed to put a fence, we have a bad water problem. So what they did, they cut a trench, about a 2-foot trench, in order to accept the water that comes in from behind us. We have requested that the DOT or either the Corps of Engineers come out and take a look at how water is dumped. So if I had put a fence there, it's going to wash out. It's going to wash away the fence if we put a fence there. So we just sort of just work together there as neighbor, and if we do put the fence, it's going to be more of a problem than anything, and the way the water comes in, the way we're trying to direct the water to go back to the drainage.
Okay, so there's an active erosion issue, it sounds like, with respect to
Yes.
the water,
Bad,
the flow
real
of water?
bad. Yes, yes.
Okay. Regarding the delivery of parts, do you have a projected business hours for the business?
Yes, we are open from 8 until 5.
And are you currently running the operation at that location, or is it?
I can't do nothing until we get a
Okay.
permission.
And that's open from 8 to 5. What are the days of operation?
On Monday through Saturday. Yeah, Monday through Saturday.
Monday through Saturday? Okay. Okay. That's all of the questions that I have. Do you guys have any follow-up questions? No? Okay.
May I ask a question?
Yeah, certainly.
I am confused about who's my commissioner. Is it 1 or 4? Well, this property,
right.
this property is very confusing. I don't know whether I'm in zone 1 or am I still in 4?
You're still in 4.
His lines have moved. Yes,
Oh,
your lines have moved over time. You used to be, yes, and you're very close to District 1. So I can
Yes.
see why.
So it's very confusing because when I came up and put the application in, it was confusing about
I see.
what district am I in. So.
Yeah, it's very close, that line between myself and Commissioner
But
Gamble.
it is
But it is in
definitely
District 4,
4.
yes.
Okay. Thank you.
It is in District 4. Okay, well, I'm glad that you shared some clarification with respect to delivery of appliances, because in reviewing this application, I thought that it was going to be an on-site appliance repair shop.
No.
So, good. I'm glad to hear that it's not. Okay. Well, with that, I am prepared to make a motion, if there aren't any other questions. Nope. Okay, I make a motion to approve OB 25 and the change of the use from the thrift store to parts and appliance parts delivery.
Yes.
Okay. With the following stipulations: there to be no appliances delivered at the location. Delivery is restricted to parts for the appliances. The business hours are from Monday through Saturday from 8 a.m. to 5 p.m.
Agreed.
Let me just take a quick look at the stipulations from 2011. No. No, I know. And also, it will be for this use and this use only. Any changes to come before the Board of Commissioners as an other business item, much like the approval in 2011.
Yes.
I'm going to leave that there. Okay. All right. That's all that I have.
And all other stipulations to remain in effect, not otherwise in conflict?
And one question about that, since Mr. Baskins brought it up, did the board want to address deleting the fence since they have an alternative solution to that?
I don't think that I do.
Okay.
Because there may be a solution at some point, while now may not be it, but I'd still like to leave that stipulation.
Okay.
Any other comments or questions from commissioners? Commissioner Burrow?
When you say for this use only for delivery of parts, does that also include office? I mean, if he
Office
wanted
what?
to work on his books or office space?
Oh, I see. No. Okay.
No, and also, the office space, I also agree to having the office space at that location.
Yeah, if we're just going to have an office space.
Right,
Yeah,
right.
physical office, that's all we need.
Right.
Okay. All right, we have a motion and a second. We'll go ahead and call the question. The motion passes 5-0.
Thank you.
You're welcome.
Okay, last item on the agenda is other business, item number 28 of 2022, which is to consider a stipulation of site plan amendment for East Cobb Senior Living LLC regarding rezoning application Z41 of 2010 for property located on the south side of Lower Rouse Road, east of Cove Drive, in land lots 1114 and 1115 of the 16th District. The applicant is present. Is there anyone here opposed to other business item number 28? Let the record show there's no one opposed. Oh. Concerned? One concerned, no opposed.
All right. Well, go ahead.
Good morning, I think. Commissioners, for the record, my name is Park Suffolk Law Firm of Sam's Larkin and Huff, and I represent the applicant. And the last two cases went rather quick, and I'm going to take that lead too. They were both approved, so a short presentation might be the way to go. This is a case that was on the consent agenda. There was one item that needed to be addressed, a technical item, and I think we have that addressed now, and wanted to just bring this up. But one, this is Sterling East Cobb. If you haven't seen the facility, if you haven't been to it, it's a wonderful, wonderful facility that's celebrating its 10-year anniversary. They do tremendous work there. They have also been very open to the community. Prior to COVID, they would have a lot of events there and forums and things like that. So wonderful client to represent. The proposal is to add 2 new cottage buildings in the very southern end of the property. You can see here basically where that southern eastern portion of the property where the parking lot kind of flares up a little bit. There's a proposal to put 2 new cottage buildings there. Tremendous demand for independent cottage living, and so they want to add 2 cottage buildings there. We met with ECCA, we met with Kings Cove. They're all supportive of it. My letter of agreeable stipulation dated June 15th with the condition change that I read in previously. ECCA supports dealing with item number 4, dealing with that the no parking on adjacent public roads, including adjacent neighborhood roads, was the one change there. The DOT condition had a donation that said compliance with previous condition from 2010. This was developed in 2010, and they have in their comments for 50 feet of right-of-way donation. We've donated up to 35 feet from the center line, 50 feet from the center line. And if it's 50 feet, we've got our sign, there's the topographical changes, we've got setback for the 4 different cottages there. And this is on the LDP that's going to be pulled is for the very southern end of the property. Doesn't have anything to do with that. ECCA has weighed in and very much supports not donating that additional right-of-way because that's heavily landscaped, beautifully landscaped, wonderful entrance. And so, and this is a 3, you can see from the aerial, it's 3 lanes currently, 2 travel lanes and a center turn lane. And I'll whisper this, there's no plans to widen Lower Roswell Road to 4 lanes, and I don't think that there would ever be plans to widen it to 4 lanes. It's not that type of roadway, and I think the community would be very upset about 4-laning Lower Roswell Road. So DOT doesn't have any plans for it, so I don't think they have an objection to waiving that. It's just part of their requirement that in this arterial road situation, 50 feet from the center line. We've already gone through plan review 10 years ago, donated the right-of-way needed for that section here. That's all we're asking is just that one DOT comment be removed for the right-of-way donation. Thank you.
Thank you. All right, John, what is staff's recommendation?
Madam Chair, the staff would recommend that the Board of Commissioners approve the request, subject to the letters of stipulations from Mr. Parks Huff dated June 15, 2022 and June 16, 2022. Cobb DOT comments, except for the donation of right-of-way, water and sewer comments, stormwater management comments, and fire department comments.
All right, Commissioner.
Sure, I didn't know if we wanted, I didn't know, Christina, if you wanted to. Could she have been sworn in or?
Oh, thank you. I didn't ask, well, we did ask if there was opposition, but did you want to state your concern as part of opposition? Yes, ma'am. I'm sorry about that. Please come forward. Thank you, Commissioner.
I think we're in good shape. The ECCA does not, Jill sent me this. I'm Chris Lindstrom representing the East Cobb Civic Association, and Jill Flam and Rick Rome were case managers. Neither one could be here today. ECCA does not, so Jill sent me her response here. Jill, ECCA does not support the donation of the right-of-way requested by the DOT with regard to OB 28. The landscaping and look of Sterling Forest along Lower Roswell Road was and is an integral part of the project and something the community does not want to see removed now or in the future. So we're in agreement with removing it.
Thank you.
Thank you.
Go ahead, Commissioner.
Thank you. Amy?
Amy Diaz, DOT.
Hi there again. With regards to the staff comment, is there anything that we need to consider as a board on the request of removing?
No, I discussed it with the attorney before the hearing, and basically when we have a land disturbance permit, we recommend that all frontages come into compliance. Since the roadway is an arterial, that would be 50 feet from center line. I will point out that landscaping doesn't necessarily restrict that donation because there are landscape licenses. We have other places that do the landscaping within the right-of-way, but he is correct, there is no planned project. I told him that if it would be then up to you whether or not that could be waived, and if it was not waived, he was also concerned about some setbacks. And I said that that could also be addressed at the same time if it is not waived.
Thank you for that clarity. All right, and Parks, you can back up. So, because I know we did read in some edits earlier when it was on consent. So just to capture what we were looking at before I make a motion on this, it was around the no parking for adjacent neighborhoods in addition to the no parking on the public roads. And then removal of the staff comment for DOT, which was Part B here. And then the last thing that I was referring to was that you agree to review previous stormwater issues and compounded impacts as a result of the additional units in coordination with stormwater.
We're certainly agreeable to that.
Okay. All right. I believe those are all of my comments and questions. Is there anyone else on the panel on the dais that, all right, fantastic. I will make my motion. Motion to approve OB 28 with the stipulations read into the record earlier. The letter provided by ECCA June 15th, in addition to no parking on the public roads and adjacent neighborhoods. Also that the applicant agrees to review previous stormwater issues and compounded impact given the additional units in coordination with stormwater, and to come up with a plan to address such issues. And all other staff comments not otherwise in conflict with the removal of that Part B under Cobb DOT's comments, which was, just for everyone's awareness, it was the donation of the right-of-way, that is no longer required. I think that ends my motion.
Staff comments?
I said that part.
All right, great.
Okay. I'll
Okay,
second it.
okay.
And then just for clarification, you're not going to remove the original 35-foot right-of-way that was given?
Correct. That was
Okay.
done on the previous zoning.
I just wanted it to be clear that your motion did not remove all right-of-way donations, just essentially the additional 15 feet that's not required.
Thank you.
All right. Any other comments or questions? Call the question. The motion passes 5-0. Thank you. Was it clear who seconded that motion? Okay. Commissioner Gamble, you seconded that motion, right? Okay, just wanted to be sure. All right, very good. That concludes today's zoning hearing.
Chair, we do have a 1:30, so if we can just reconvene and announce the further reconvening of the conclusion of the appeal hearing for the Historic Preservation Commission.
Certainly. Yes, for those who are still with us, we will be back at 1:30 to continue our historic preservation hearing from about, was it a month ago? And you are free to join us at 1:30 p.m. Thank you.